that the government has, for instance, in Nigeria, the government of Nigeria is really investing a lot on surveillance. It paid over 10 billion naira recently for WhatsApp gadgets that can help to surveil WhatsApp information. Now, however, we have issues where there have been several journalists who have claimed, not only claimed, they've been charged to court. And what really has been the problem is the issue that the Nigerian government would access their information through another journalist or another friend's phone number, which they retrieve from a telecommunications company. They do this without getting a court warrant. And interestingly, they've been enabled under the Nigerian Communications Act and then the Interception of Communications Regulation of also the Nigerian Communications Commission. So the difficult situation that a lot of these journalists find themselves is that they see a call from a friend or a colleague asking them to come over, that there's something important they need to talk about. Then they leave that place and go to the friend who is in need, in quotes, and then they find out that it's the police that is arresting them. Now, the spokesperson for the Nigerian police had said on several occasions that what they do is to partner with telecommunications companies. And so the question really basically is, why should a regulation, why should a commission, which is also a government institution, be the sole, how would I put it? Why should it be the sole authority when it comes to interception? So the problem, the legal problem that is arising now is that there is no oversight function from the judiciary. So there are no checks. And so when there are no checks, the government will come and, as the defense that they've put up so far is that they are trying to protect national security, public safety, public security, public health. So they go to the provision of Section 45 of the Nigerian Constitution and use that as a basis for the legality of the regulations. And interestingly, the regulation is actually gazetted in Nigeria. So we've had situations, of course, there were situations where they might have been able to actually arrest a criminal, but now the problem now is you have journalists who have not committed any crimes. What they have just done is publish their stories, and when they publish their stories, the Nigerian police or law enforcement agencies cannot reach them, and then they go and then breach these privacy protocols or privacy rights, which becomes the major issue for us today. Now, interestingly, most of these cases, it's always criminal charges against them, and it's always on maybe criminal defamation. It's not like it's basically on their work, on what they have done, whether they've published their stories online or whether they've published stories which the government is not comfortable with. And then and that has been a big problem, because on one hand, we have a regulation that has been gazetted in Nigeria, which is claiming that which says that the Nigerian a senior officer with or a senior ranking officer can go ahead to give an approval to the police to go to check out to communicate with a telecommunications agency, check the person's information, who are they having communications with, then what are they get all the contacts. And so they keep doing this. And then the question for people like me who really believe in the right to privacy is, what now happens to the provision of the Constitution, which says that you have your right to privacy, and your rights should not be infringed upon, should not be violated, except in circumstances that are lawful. So the issue now is, by going behind and doing all this, I still, from my submissions that I've been writing something on this. I think, and I'm very certain that using these NCC communications is unlawful in itself. It is unconstitutional, and that is the basis for how do I say it? For a future, because there's something in the works where we want to challenge this in the court of law under the Fundamental Rights Enforcement Procedure, that it is unlawful, this regulation is unlawful in itself because it is not constitutional. And then, of course, while stating it is unconstitutional, we would be arguing along the lines of the three rules of the international rules on the what they call it, whether it is legal in itself, whether it is lawful, whether it is legitimate, and whether it is necessary in a democratic society for the Nigerian government to allow the interception of communications or interception of or surveilling its citizen without a judicial oversight. So when you do it on a large scale, when you do it on an ambiguous manner, then it becomes a problem, because you have not presented why this particular individual should be surveilled, why this particular communication should be surveilled. You haven't presented it before a court of law. And it is the court of law that should now decide whether you have brought up sufficient reasons, whether you have cogent reasons for going ahead to surveil or to intercept communications. So that is basically the line that I'm bringing in the discussion from, and I think we will continue when every other person has had one or two things to say about it.
Thanks so much, Monturayo. That was a really great introduction to the situation in Nigeria. So now if I can hand over to Adam Remport, who is the legal officer on the privacy project at the Hungarian Civil Liberties Union, to discuss a bit about the work on cases regarding Pegasus surveillance.
Sure, and thank you for the opportunity. Actually, what I'm going to present is going to be quite similar to what Monturayo has just said in many respects. So, as you might know, Hungary is one of the EU member countries that was actually affected by the Pegasus scandal, in which a military-grade spyware or cyber weapon was used against several people who were critical of the government, or who, for some reason, were just problematic for the government, including journalists as well. And we are representing presently 7 clients in such cases. 4 of them are journalists. And well, what I can say is that it is quite difficult indeed in Hungary as well. In fact, it is not possible in the Hungarian to win these cases in the jurisdiction of Hungary for several reasons. One of these reasons is that according to Hungarian law or legislation, all surveillance is technically lawful. Surveillance by the National Security Services can be ordered on very broad grounds. The National Security Services technically only have to say that a given information cannot be obtained in any other way, and that that obtaining this information was necessary for undertaking their functions. And the person who is going to decide on these really broad grounds is actually the Minister of Justice, who is of course not an independent body for authorizing interception or other kinds of surveillance, because they are a member of the government and they are probably supportive of the probable illegal surveillance that they are authorizing. But this is not the only problem. The other problem is that there are no effective remedial institutions in Hungary. So the default route for lodging complaints, if you think that you have been surveilled, is the default remedial institution is a complaint to the minister overseeing a given national security service. As you may think, this is actually not an effective remedial institution. The minister is not going to investigate the case properly. And if you are not satisfied with what the minister has found, which is going to be nothing, so that everything was fine, you can lodge another complaint to Parliament's National Security Council. The problem is that the governing parties have a majority in the Security Council. So if they abstain from taking part in an investigation or taking part in a session of the National Security Council, there is not going to be a quorum. So the council is basically a lame duck. There are other options as well, such as the Data Protection Authority, which is, well, it cannot really be considered an independent body either, because its head is technically chosen by the Prime Minister. So even though on paper the DPA is quite independent, the person who is going to lead the DPA is and has been a loyalist of the present government, and he's chosen for 9 years, which just entrenches a person close to the government in this most important form of data protection. Also, the DPA does not have enough investigative power to investigate secret surveillance. So, for example, classified data can be withheld from the DPA if a national security service claims that such data pertains to persons who collaborate or cooperate with the given national security service, or if it contains the technical details of technology that is being used by the given national security service. Now, the DPA can actually say that they don't accept this decision, but they can only complain to the minister again, who is going to investigate the case and obviously find that the National Security Service's claim was legitimate. So what remains are the Ombudsman and the courts. The Ombudsman is called the Commissioner for Fundamental Rights. He technically has the same investigative powers as the DPA, so I'm not going to go into details about that. The problem with the courts is twofold. First of all, you have to prove that your data is being handled in order for a court to rule that the data controller has to disclose data being controlled on you. So first of all, you would have to be able to prove that you had been surveilled by a given national security service and that they are holding data on you. This is almost always impossible because of the nature of secret surveillance. So it is these cases usually stop at the beginning because you cannot prove that you had been subjected to secret surveillance. But in cases where this somehow becomes apparent, mostly by mistake, or some kind of mistake on the security services part, you can still lodge an access request to classified data to the National Security Service that you suspect had been watching you. The problem is that they are going to evaluate whether you can have access to the classified data that they are holding on you or not. They will always deny access to your classified data, and then you can go to court. And unfortunately, what we have seen so far has been that the courts say, or they accept the Secret Service's position in these cases, that even the smallest amount of data disclosed to the data subject could have detrimental effects to the workings of the national security services, because in this way, that single person would be able to draw conclusions on the working methods and of the national security services and their interests, what cases they are interested in, which must be therefore prohibited or not allowed to the data subject, in order to keep the secrecy and functionality of the national security services. And this technically means that you can never access classified information being held on you, despite the fact that you would only be able to gain access to a part of it, not all of it, and you would be prohibited by law to disseminate it, or indeed to just tell any information about it to anyone, because it is a criminal offense. It would be a breach of classified data. And even in this situation, the courts side with the security services and say that such permissions cannot be granted. This is why we are going to go to the European Court of Human Rights. We are also looking at possibilities to avail ourselves of remedial institutions at the United Nations. And in the meantime, we are, of course, exhausting all domestic remedial institutions, however ineffective they might be, so that we can present to Strasbourg, the European Court of Human Rights, that indeed all of Hungary's legal system is incapable of providing remedy to those who have been subjected to illegal surveillance. In the meantime, we are cooperating with our partners, international partners. In the communication of our cases, we think that it is of paramount importance to raise awareness to such illegal surveillance and to put pressure on all of the governments that abuse personal data in such a manner, and who, of course, even make the work of journalists impossible or risky in such a manner, because they cannot safely communicate with their sources. So these are the things that we are trying to fight against, and it is an effective remedial system that we would like to achieve. Thank you.
Thanks so much, Adam. So now we can move on to my colleague Saba, who is the Senior Legal Officer at Media Defence, and she can talk a little bit about what we're doing on surveillance.
Thanks so much, Hannah, and thanks so much for Mujaro and Adam who I think have provided a really kind of good overview of the regional difficulties within countries people are finding in terms of litigating cases that concern privacy or surveillance. I thought it might be useful to kind of provide an overview of some of the kind of trends that we're seeing in the course of our work. As you've heard from kind of the other panelists, online surveillance of journalists, human rights activists, lawyers even, is increasing year on year. And that communication surveillance, whether that be, monitoring, intercepting, collecting data, is becoming a central issue. And for us, a number of kind of key elements stand out. And if it's possible, I can probably talk about two and discuss briefly their impacts when trying to secure accountability through litigation. So the first thing that we're seeing is the use of these kind of broad, vague laws that do not provide effective protection of journalistic sources and material. And the second trend that we're seeing quite often is the confiscation of devices, generally at borders, of journalists or human rights defenders, which is inevitably going to impact the course of their work. So in terms of the first point and the use of these broad, vague laws that we're seeing, one of the things that, the cases that are coming to media defense is that lawyers within countries are trying to challenge these legal provisions that are broadly defined, and they're exposing journalists, especially investigative reporters, to greater threats of surveillance and harassment. And media defense obviously works and supports such lawyers in Africa, but more widely, who are litigating these cases through the court system. So I thought, given we've heard from Adam and Modiraya some of kind of like the specifics of litigating particular cases within their respective jurisdictions, perhaps it would be good just to kind of give some examples of arguments that we consider at media defense when litigating these cases or when dealing with kind of like amicus briefs that deal with issues around privacy and surveillance and the impact that has on journalists and news outlets, for example. So a couple of the kind of key arguments that we look at is kind of comparing looking at these kind of legal provisions through the lens of like the comparative human rights framework, to see, the applicability of that violation of privacy. We look at obviously the nature of the data being captured and the intrusive nature of that, and whether there are arguments that can be made within the brief about those kind of monitoring or obligation, monitoring and kind of analyzing of data. One of the other things that we look at is the kind of the necessary safeguards, or normally the lack thereof, within these legislative provisions for journalists and investigative reporters. And then obviously the impact of these provisions on the right to freedom of expression on journalists as well. And perhaps I can just pick on 2 points just to kind of give you a little bit more in-depth kind of detail about some of the kind of points that, or the arguments that we might kind of expand upon within the brief. And going to the first point, which is to do with the comparative human rights framework, one of the things to always argue, one of the things that we always look at, and I think it was touched upon by Modiraya in her kind of contribution, was that the standards by which an interference with privacy must be assessed, and they're kind of well established in international law and human rights jurisprudence, and that comprises of the kind of the 3-part test, as was mentioned earlier. So the interference with privacy must, for example, 1, be in accordance with the law, 2, serve a legitimate aim, and 3, be necessary and proportionate in relation to that legitimate aim. And often this kind of international reading is consistent with domestic kind of legislative provisions within the Constitution. So these are kind of, going through the 3-part test, applying it to the facts, and then being able to apply this to compel the courts that actually the intrusion or the violation of privacy here on a particular individual, such as a journalist, is not justified. The other kind of point to look at is the impact that this has on journalism. So obviously, you know, surveillance and monitoring of data for a journalist, especially in a investigative kind of reporter, is detrimental. And one of the impacts of surveillance that we consider when we're looking at the briefs is this issue of news gathering. So while obviously a journalist's role is not only to kind of impart information and ideas of public interest, they must also be free to kind of gather, collect and assess such information. And it's that kind of element of news gathering which can be, you know, massively hindered in the course of surveillance that is carried out by governments or other kind of actors. And one of the arguments that we put forward normally is that without kind of this news gathering function, journalists are unable to perform their kind of their public watchdog function. And it's vital, you know, especially in the context of investigative journalism, that you know, journalists' information is kept confidential, their kind of sources are anonymous, and they can really only effectively work where those materials are protected. And in kind of making good that assertion, we normally rely on various kind of standards through both the international courts and potentially in any kind of standards we can find within the domestic jurisdiction that we're kind of litigating or assisting the lawyer with. But obviously, you know, in terms of international courts, they've over a number of years, they've developed standards to be applied in circumstances where the disclosure of journalists is, or journalistic sources is sought. And both kind of national and international courts have made clear that a disclosure order or kind of any other interference with a journalist source will be unlawful unless there's what's called an overriding requirement in the public interest. So for instance, to prevent the investigation, to prevent or investigate a major crime or act of violence. So in that regard, there must be adequate legal safeguards in place. And that's something that I think, you know, both what speakers touched upon, but the fact that there are, you know, especially what Mojiro was saying, was that this lack of oversight or in order to kind of assess or independent assessment that's going on when, especially in the case of journalists, kind of data that's being taken, given the work that, you know, the data they're holding may kind of have such a important public interest, and it's really going to hinder the work that they are doing. And it's important because those standards, you know, which we kind of mention or we kind of detail in the brief, are not only in an attempt to directly and deliberately disclose, for example, the identity of a source, but also to an interference that's otherwise that's capable of or indirectly having the effect of identifying a source. And that goes to the kind of the chilling effect that this will have on kind of reporting within the country or more widely. You know, any kind of hint that there may be a compromise in place of a journalistic source is going to obviously impact reporting and sources coming forward to journalists to be able to do their kind of work in a manner that is useful for the public and for them to be able to report. So in that regard, you know, protecting the identity of sources adequately, it's necessary. And any kind of, we would say, any kind of directive or legislative provision that's likely to lead to the identification of a source, including potentially the factual circumstances of acquiring that information from a source and personal data of journalists relating to their work, needs to kind of be assessed by kind of an oversight body, or there needs to maintain some sort of judicial warrant that might be that's available that once kind of each factual circumstances has been assessed. So In terms of those arguments, maybe I can kind of give some examples of some laws or directives that kind of illustrate these points of, that have been drafted wide enough to kind of capture journalists and investigative reporters within those provisions. So I think there is a case that's currently or was going on in the Kenyan Supreme Court, which was challenging a directive that had been issued by the Kenya's communication agencies, which required all mobile networks to facilitate the installation of this management system, known as the device management system, to access subscribers' information. It was a central equipment that identified a register, and it was kind of operating as a shared database. So discussions that having had a look at that directive was that in its current form, it was, unduly vague. It was very broad. It didn't really provide any guidance as to what constituted as confidential data that would be collected. There was no kind of provision or guidance or detail how exactly that data would be used. And on that basis, there's an argument to be made that it's in breach of the requirement that restrictions and freedom of expression be provided by law. And the fact that it wasn't sufficiently clear and precise to allow an individual to kind of regulate their conduct accordingly is something that both contravened international law and, the Kenyan constitution. Another kind of example where, broadly drafted provisions that are impacting journalists' work comes from the Anti-Terrorism Act in Uganda, where some of those sections are very broadly defined, and they provide for the surveillance of anyone associated with terrorist groups, and they create insufficient safeguards for journalistic reporting. I think that law has gone through a number of revisions, but currently it allows for secret surveillance under one of the sections. So it allows a minister of the country to kind of appoint an authorized officer to kind of secretly intercept the communications and the search premises of any individual suspected of, the offence under that act. And there are serious, obviously, concerns that that section has a chilling effect on preventing individuals from expressing themselves, which is obviously contrary to freedoms guaranteed by the Ugandan constitution. The kind of concerns around that provision is, again, similar to what we've heard before, the lack of any kind of independent authorization that kind of looks at when this secret surveillance is able to kind of be applied or implemented. And again, we've heard from the other speakers, one of the other kind of concerns about this provision is that there is no kind of warrant that is required. There's no judicial warrant that's required. So there may be so the subject or the person that's the subject of the interception or the surveillance may not really have any means of finding out whether their communication has indeed been intercepted, and there's no kind of clear path to seek any redress. So clearly, journalists and their sources may be the target of surveillance here, and generally it just provides a very kind of chilling effect. Just a threat of potential kind of surveillance measures on journalists is going to have a chilling effect, and risk kind of self-censorship by journalists, or any kind of critical or controversial reporting may kind of not come to light because there are worries by those within the jurisdiction that might, that they may be targeted under this provision. The second issue I kind of want to briefly touch on that I mentioned earlier was the confiscation of devices at borders. And over the last kind of past few years, we've seen like a dramatic increase in the number of searches of mobile phones and other electronic devices that have been conducted at borders by various authorities. And frequently this is under, national security or terrorism legislation. And often those searches of those devices are in the absence of any kind of judicial warrants. And what we're seeing is that the authorities can and often do confiscate devices for lengthy periods of time and then subject them to, extensive examination. And often those practices are in violation of an individual's right to privacy and freedom of expression. Obviously, devices, electronic devices, including laptops, mobiles, iPads, contain, especially for journalists, a range of data ranging from their emails, their messages, their social media profiles, photos, and then obviously browsing history. I want to kind of highlight two cases just to kind of end in a somewhat positive mode of cases that have been litigated that deal with this, deal with the confiscation of devices at borders and, have challenged that through the court system and have got relatively positive outcomes, which kind of goes to show that, the courts are now quite receptive in certain jurisdictions of, this kind of tension between privacy and national security, and where that is being argued in these two cases, we've received some good results, and they're quite recent cases. So one is a case that relates to a filing in the US where a number of plaintiffs, including a journalist, sued the Department of Homeland Security, and they challenged the government's kind of fast-growing practice of searching travelers' electronic devices without a warrant. And they sought to establish that the government must have a warrant that's based on reasonable suspicion or some sort of probable cause to suspect there's been a violation of the local law, whether that be immigration or custom laws, before going ahead and conducting such searches. And they relied on two kind of written directives that kind of authorized such searches to take place. And in their kind of pleadings, they argued that each of those directives did not permit the use of any warrant or kind of any oversight. And there was no kind of basis or threshold for a authority figure to kind of consider that didn't need to be any suspicion for those searches and those confiscation of that kind of those mobile or electronic devices to be kind of taken in. And I think it's going through various kind of appeal courts, but initially the initial decision was that the district court ruled that the government's kind of actions in kind of obtaining these devices without any suspicion actually violated the kind of plaintiffs or the travelers' Fourth Amendment rights. As I said, I think that's kind of going through because it's being appealed, and it's, correct me if I'm right, I think it's still pending in one of kind of the appeal courts in the US. Similar to kind of a similar case was seen very recently actually in the UK, where asylum seekers brought a case to the High Court which claimed that the kind of the Home Secretary was operating a secret blanket policy to seize mobile phones from people arriving on kind of small boats and then downloading the data from them. And within the arguments made when this was being argued was that, the officials were bullying those arriving into kind of handing over their PIN numbers so that officials could unlock personal information, look at emails, photos, videos, and then download them into an intelligence database called Project Sunshine. And judgment for that came out very recently, a few weeks ago at the end of March, where the High Court ruled that the Home Office had actually acted unlawfully and breached human rights and data protection laws by the mere fact they were operating this kind of secret blanket policy of seizing and retaining and extracting data from the mobile phones of these asylum seekers that were coming to the UK between April and November 2020. And it's, I think these kind of judgments are going to show that obviously where we're seeing a lot of kind of data retention and a lot of kind of ways that governments are trying to extract the data of individuals, that is for our work obviously going to impact journalists and press freedom. It is now being litigated through the court system, and some of the kind of judgments that are coming out are showing that you know, these do contravene kind of international standards, and they do contravene national kind of data protection laws as well. So it's worth, you know, sometimes in the course of our litigation, you know, when we're speaking to clients, when we're thinking about cases, sometimes, you know, having these positive judgments can just be a way of giving us hope that, you know, despite the fact that there are many tools being used by governments at the moment to kind of infiltrate and trying to survey individuals, there is a recourse through the kind of the court system at the moment. Hopefully, I'm hoping I've kept to my time limit, but I'm happy to kind of answer any other questions in the Q&A. But that gives kind of a brief overview of some of the stuff that media defense is looking at when we're dealing with privacy or surveillance issues in our casework.
Saba, thank you so much for that great summary of what we're working on at Media Defense. So now I'd like to see if anyone has any questions for our panelists. So I think there's a hand raised in the group. If not, then oh, Adam has his hand raised. So yeah, Adam, I'll hand over to you.
Yes, I've raised my hand because I received 2 questions in the Q&A section, I believe. So the first was how our clients found out that they had been surveilled by Pegasus. Actually, I don't know the exact details because the journalist who was contacted by the Pegasus project and the other international news agencies, media outlets that took part in investigating the Pegasus affair. He was already contacted by people who knew that his number was among those that had been leaked, and they received a data set of 300 telephone numbers. I don't know the exact method by which they find the people who had been targeted by Pegasus, but it is true that of the people that they have contacted, many have asked for forensics to be undertaken on their phones, and several have found traces of Pegasus. So it has been corroborated by Citizen Lab and Amnesty Tech. And the second question was whether a non-independent DPA is compatible with the GDPR. No, it's probably not, but I think that the main issue is not necessarily that the head of the DPA is technically appointed by the Prime Minister, although, of course, that is, legally speaking, it is a huge issue, but in the Hungarian system or under the Hungarian circumstances, even if the head of the DPA was appointed or chosen by the parliament, it wouldn't really make any difference, as Hungary is, well, as they describe it in international publications, sort of a hybrid regime where even parliament is controlled by well, one party and its leader who affect almost complete control over the entirety of the state. So the problem is that neither bodies of the Hungarian government are independent in this sense, except for parts of the judiciary which could not be subdued so far, but we believe that they are going to be the next target. So, long answer short, it is a systemic problem. I don't think that it can be reduced to just the infringement of one section of the GDPR.
Great, thank you, Adam. So I think we've got a question from Idris, if you'd like to ask it. Or I can read it out. So the question is to all the panelists, how can a journalist protect his privacy while freelancing to many media organizations and having exposed his data in many online platforms? I think
Sorry. Yeah, perhaps I can just give some pointers. I know that there's various kind of organizations and coalitions and networks that look to try and protect freelance or journalists in terms of giving them information about digital security. So happy to kind of look into those and send those kind of details over offline. But generally speaking, you know, some of the stuff that we've just heard about when kind of looking at digital security is trying to obviously protect your information as much as possible on your devices. So whether that's using apps that, you know, are encrypted. I think there may be apps available that don't even require you to use to provide your phone number, but they give you kind of a unique ID number. If you are corresponding or communicating with sources and there are concerns whether, you know, that communication is to be intercepted or may be compromised, you know, and the phone number may be a way of leading someone back to identification. There are apps available out there that kind of look to kind of conceal your phone number, but still allow communication to happen. Obviously, you know, there are methods of controlling your browser, encrypting your emails, but there are various kind of coalitions that will work with journalists to and kind of give them more information about being a bit more savvy with your digital security. And often they can be not very intrusive measures, but they can be just little kind of pointers that you can take on and kind of implement in the course of your work to try and protect yourself as much as possible. Obviously, you know, if someone wants to kind of access your information, often governments have very powerful tools, but it's to try and make it as difficult as possible. And some of these kind of ways of encryption are ways of doing that.
And Roger, right?
Okay, I just wanted to add that when it comes to protecting yourself as a journalist, you need to take security trainings. You just don't, yes, I totally agree with Saba that you do be very cautious with whatever you're doing and using the right kind of tools to protect yourself, but overall, you really need to take security trainings. When you take security trainings, they will tell you the right kind of apps and the right kind of things that you can do to protect yourself and protect your data and protecting your source. So I think that should be a priority for every journalist who is on this call, because I happen to be married to a journalist, an investigative journalist, and he has done a lot of risky journalistic investigations that could have gotten him into problems. But because he at an earlier stage was taking a lot of security training, so it was easy for him to have avoided issues where whatever method he was using to gather his information was intercepted. So, for instance, I had mentioned that there's a particular journalist in Nigeria who, I told you that the government was able to use the information on his phone, which they got from a telecommunications company. They used it to arrest him. So one of the ways I think for you at the moment of having calls with your source is to try to use Signal, for instance, because I think Signal has been a little bit difficult for them to intercept at the moment. But as Saba said, they have some kind of gadgets and technologies that private individuals do not have. So there's already an imbalance. So, but I think with a good security training, it should be good.
Thanks so much, Modiraya. And were there any, I still see some hands raised in the group. Are there any additional questions that anyone would like to ask before we wrap up today? Yep, if you have your hand raised, please just ask the question. Okay. So, yep, I think you should be able to unmute yourselves now.
Hello, thank you very much. I'm Idris. I appreciated your answers on the question I raised on the privacy of journalists. I'm also a journalist who is covering extreme terror-related issues in northern Nigeria. I was a victim of this data privacy stuff. It happened last year. I explored a story about Ansar Group in the Northwest region, and I posted the report in one of the international newspaper organizations. So few hours after they published the story, I got a call from State Security Service inviting me to bring myself, or they know where I am, either will come and just apprehend me. When I brought myself to them, later I realized that they got my information from national media, which I worked with them for a few months before I resigned and became a freelance journalist. So my still question is part of the data protection. So can I sue that particular media organization for releasing my information despite the issue of protection of confidential source? And I haven't committed a crime which fall under section 45 of the Nigerian Constitution. Can I go ahead and sue them for releasing my information to the security?
Yes,
Hello?
you can, Idris. Yes, I'm picking up the response. Yes, you can actually do that, and I think if you how do I say it? Okay, now you have a good. To me, you have a good case against that. Although I try not to give legal advice on panel discussions like this, so it will just take you. You really need to get to a lawyer who deals with digital rights and protecting media rights. So with that way, the lawyer can better give you advice on you going forward with such a case. And I think in this kind of circumstance, you do have a case. And of course, it still borders on the statute of limitations also. When did it arise? Whether you can still sue at this time. So there are so many questions. So just talk to a lawyer directly. I think that would help.
Okay, thank you very much.
Would one of the other two, Kawai, would you like to ask a question?
Yes. Okay. I don't know. Can you hear me? Can you hear me?
Yeah.
Okay. My question, I'm not actually a journalist, and I don't know much detail about these things here. But I've been following these things, and I've been staying with someone who's a journalist. Now there's one thing here. There's one thing that makes me confused. Now in my country, I'm from South Sudan. So the government, which is through national security, the government is having like this, is having access to people's phones. So when you communicate to someone, the national security tracks your communication. So they send it to the whatever to be released It happened to my friend. That thing was recorded. His voice, he was talking to someone, all those things were recorded. So we tried, we went and we litigated. We went to the court. So we explained our case to the court. Then they told us that under this circumstance, so it is the right of the national security, like to do those things. I don't know whether it is right, but it's not, because they go to your phone, they check whatever you are talking about. Like, I'm trying to mean this networking, whatever. Thank you.
Okay, thank you. Does anyone on the panel have something that they'd like to contribute?
Pardon?
Oh, I was asking any of the panelists if they'd like to follow up on that.
All right, thank you.
I don't have anything specific to say, and as moderator said, it's always difficult to to discuss specific cases of specific incidents. But perhaps I can leave contact details of Media Defence in the chat. So if there are queries, we can take it offline and have discussions there. I think Hannah's just posted her kind of contact details, and I'll put my email as well. But yeah, get in contact with Media Defence and we can discuss this offline in terms of case, specific casework, or if you're looking for a lawyer, putting you in contact with a lawyer within a particular country or region that may be able to assist with these cases and take it through the court system. That's what Media Defence does. So please, anyone on that hasn't had an opportunity to kind of like raise any questions, please do reach out to us and we can try and assist.
And there's one more hand. Hopefully we can just last one more minute, but if you could just ask your question really quickly, because we are already running over time. So there's one more user with their hand up. If you'd like to ask a question.
Hello, do you hear me?
Yep, we can hear you.
Okay, thank you. So my question is, I think, as short as it should be. And the question is how to reconcile between the national security and the freedom of media. And I want to emphasize it because of from the side of the spread of fake news and many other problems. We know there is a serious defense from the media right, but there is also another serious concern in curbing and protecting others from spread of fake news. And how do you reconcile these two important interests? Thank you.
Thanks so much. So if we could just go around the panelists super quickly, and this is just your wrap up now, and then we can say thanks to everyone. Adam, would you like to start?
Did you get the question? Well, I wasn't too sure whether I understood that question.
My understanding is it's balancing freedom of the media with questions around things like national security and fake news.
Oh, okay, that was what I was trying to refer to in my opening discussion. Or just, I was saying something about at all times when it's involving human rights and the rights, you have to be specific in this. You can't just say media rights, as it's ambiguous in a way. You just have to be specific, whether you're talking about fundamental rights or your right to assembly, association. And then, of course, basically, I know when media rights is involved, you're talking about access to information to be able to disseminate information. So yes, these are basically under the freedom of expression. And I know that for you to balance the rights of a media or a journalist or media rights with national security, there are the three tests that I've mentioned earlier, the three-part test, which of course is whether there is a law in place, whether there is a the law in place. Is the law itself, is it a legitimate law? And then, is it necessary? Is it proportional, for instance, necessary in a democratic society? And then the courts, you don't leave really basically, it's always leaving the interpretation to the court in specific cases. You have to, they will treat a particular case based on the facts and circumstances around that case to be able to decide whether how will I put it, the activities of the government, of the law enforcement, whether their claim that is basically on national security, whether it is justified in that particular circumstance. So if it is not justifiable, if it doesn't pass the three-part test, which by the way is cumulative, then it becomes a problem. And so at every point in time, the court will always uphold the rights for the media. The court will uphold the media rights. But where it is not where it is justifiable, which usually is always very slim, then you know that, oh, okay, in this particular case, the government is justified in protecting national security. So it's most times it's always left to the court to interpret.
Thank you very much, Modurayo. And then Adam and then Saba, if you can just give a very short answer, and then we'll wrap up for today.
Yeah, I think that Modurayo just gave a great summary of what the case is. Of course, I would emphasize that this is a very timely question, so it's a great question. Even many governments are struggling to come up with straight answers, but yeah, most cases can definitely be decided on a case-by-case basis. And I would just like to emphasize that I think that the starting point should always be that we should be very wary of censoring expression based on its content. So when you are censoring speech, it should be based on the effects that it can cause. So if it incites to violence, for example, if it is defamatory, etc., those are, for example, legitimate aims. But mostly it is just best to be neutral and to not restrict speech based on what it is about or its content.
Thank you. And Saba?
I really don't have much more to say, more than what Modurayo and Adam said. It needs to kind of fulfill the three-part test, and it's an excuse that's used. The only thing is, with public interest cases, that bar normally we say is higher. So, but I think it's been covered adequately by the other two.
Thank you all so much. Thanks everyone for coming. Thank you for your great questions. Thank you to the panelists for your excellent contributions. Sorry for running over a bit, but I just wanted to try and get some of those questions in at the end. We've got the contact details in the chat, so please do reach out if you have any further questions or would like to learn more about anything to do with this panel. So yeah, thank you all so much. Thanks to Paradigm Initiative for letting us host this panel, and have a great evening.
Thanks, Anna. Thanks, everyone.
Thank you. Have a great evening too.
I keep forgetting that it's muted. Okay. You two have a wonderful evening. Bye, Saba and Adam.
Bye.
Thank you, everyone. See you tomorrow.